I have a card here from Jonathan Sachs. And Jonathan, if you could also introduce your organization as well.
Thank you very much, Chairman and the committee. My name is Jonathan Sachs. I'm Deputy Director of the State Appellate Defender Office here in Michigan. We're the only state-funded public defense service provider. We represent between 17% and 20% of indigent criminal defendants pursuing an appeal. Our office was created in 1969, and we're overseen by a 7-member appellate defender commission appointed by Michigan's governor. What I'd like to do here today is to talk very briefly about Miller versus Alabama, not repeating things, but just a couple of gaps that are still in the mix, to talk about some of the client population that my office is serving. We've been authorized by our commission to represent our former clients in this process, and also, of course, new clients, to talk about something that hasn't come up much, which is the process of how sentencing or resentencing might work through legislation, and then finally to talk about why legislation, in particular retroactive legislation as a fix to Miller is such good policy and good constitutional policy. To begin with Miller, Alabama, we've talked today about how youth are different for purposes of criminal law and sentencing practices, and how it's the most recent U.S. Supreme Court case to advance that holding, that proposition. A couple of things to point out from that, though. First is that there is no question here that Michigan's sentencing scheme is unconstitutional. That is the holding in Miller versus Alabama, and there is no question that a response is needed. Obviously, reasonable minds can disagree about retroactivity, prospectivity, and those questions, but clearly a response is needed. Second is the Miller decision goes piece by piece through factors that need to be looked at in sentencing youth who are guilty of the most serious offenses. Those factors include the family and home environment, how peer pressure factored into the offense, how factors like substance abuse may have been in the mix, how somebody's capacity for rehabilitation should be looked at, and how somebody's sophistication in the criminal justice should be evaluated. These factors are important as individual factors for looking at a youthful offender, but also in terms of looking at the sentence. Prosecutor and former Judge Cooper is absolutely correct that Michigan case law right now says the remedy to Miller needs to be life without parole or life with parole. But that's because the courts were constrained. It's not the job of the courts to write legislation to say, here's what public policy should be. That's your job as legislatures, and that's why the court in Carp stepped forward and asked the legislature to act at the very least on prospective cases. And the way to stay faithful to Miller and to do what the Supreme Court is talking about is to put together a scheme where there's this opportunity for individualized sentences. The courts couldn't do it. They don't have that mandate. But there absolutely, legislatures can look at term of year sentences, can look at all these very, very difficult factors, someone's degree of participation, somebody's age, somebody's how much they were sucked up by older adults or peer pressure, and decide the best possible sentence there. The third thing and final thing I want to talk about in the Miller decision is Mr. Birch is absolutely correct. The Miller decision does permit life without parole sentences, but it makes it very clear that these sentences should be uncommon. These sentences are not the norm. And that's why the legislative response is important. We need a response that individually looks at youth who commit these offenses and who say, all right, there might be some for whom this very uncommon sentence is appropriate, but for the for the much larger group, we need to individually look at each one and give the courts the authority to do that, to impose the appropriate individualized sentence. So the role of the State Appellate Defender Office in this process. Of the 360 or so folks in Michigan prisons who are serving life without parole, offenses, about 110 of them are our former or current clients, and we are putting together a process for representing them. I think it's helpful, though. We're going to hear lots of powerful anecdotes today, as we should. It's part of making good legislation. But I think it's helpful to look at this population group as a sample set and to find out a little bit more about them. So in looking through, we found that of this 110, at least 20 of our former clients were not the actual killers in multiple co-defendant situations. Many were there under the influence of peer pressure. Some might have been getaway drivers. And this is in no way to say they're not responsible for what happened. But this is simply to point out that they were not the trigger men or trigger women, and that's an important factor. Second is at least 30 of these co-defendants at least 30 of these folks often had older co-defendants, often adults who are now serving less severe sentences. And here's why that's happened. It's very important to look at this process because this feeds into exactly what Mr. Schutte and what Ms. Cooper were talking about today. The prosecutors rightly use their discretion in the case, and they rightly say, you know what, this is not all first-degree murders are equal. And of course, a victim of first-degree murder, in that respect, it's the most devastating offense possible. But in terms of the actual facts of an offense, prosecutors routinely decide that not all are equal, and in some, it's appropriate to offer a plea bargain. And we generally see sophisticated adult co-defendants taking plea bargains, but we see 14, 15, 16, and 17-year-olds who don't know any better, whose parents don't know what actually happened, who say, no, you didn't do it, go in front of the jury. We see those folks saying no to plea offers. So we have clients who are not so culpable or not as culpable, 15 and 16-year-olds, whose much older adult co-defendants have been released from prison or are serving much shorter sentences. This is what Miller is talking about when it says, let's look at the sophistication in the criminal justice system as a factor. At least 29 of our clients had plea offers below the mandatory sentence of life without parole. Many of them are judges who said on the record that they wish to impose a lesser sentence. But because of the process and because this is, there was not legislation in place and because of the series of statutes that Professor Thomas talked about earlier, there was not that discretion. And because our clients didn't know any better, those plea bargains were not taken. These examples really demonstrate what Miller was all about, that our clients who were accomplices, who were unsophisticated, should have the opportunity for individualized sentencing. The average age of our clients now is 35.6. Many have served more than 20 years in prison. Our oldest client now is 61 years old. He's already served 42 years in prison. Over half of our clients were either 14, 15, or 16 years old at the time of the offense. This is not a case where almost all of them are 17-year-olds who are now, everything's different because of Miller. 92 of our clients, the vast majority of them, are in the lowest security levels, either 1 or 2 of the Michigan Department of Corrections. 18 of them are still in high security levels, but give or take, about 90% of them have shown good adjustment to being incarcerated. Again, an important factor to look at. So that's a quick snapshot of what's going on in the world of our clients. Obviously, they're all guilty of first-degree murder. That's not something to be forgotten either. So our representation of these clients in the process. And this is for both proactive cases and hopefully, if there is retroactive legislation, for retroactive cases. We feel that in some cases, as folks referenced, there will be mitigation hearings and Miller hearings where the factors mentioned by the United States Supreme Court will be considered. We also feel that in a large number of cases, there is room for a negotiated solution. A lot of prosecutors' offices, the first time around pretrial, offered plea bargains that our clients should have taken, but they didn't know better. That doesn't mean that they necessarily should be allowed a second bite at the apple, but it does mean that now that they're older and more mature, we expect that many prosecutors will offer similar sentences, and that many of these cases could potentially be negotiated after the first-degree murder stage. Certainly, legislative work group met a number of times, and there was agreement between prosecutors and defense attorneys there that there are some cases that could be negotiated and some cases where a term of years sentence is appropriate. We agree completely with Prosecutor Cooper that judges need complete information at these hearings. These are not some hearings to be rushed, to be taken lightly. They will be proper mitigation hearings. Everybody should have a voice, especially the victims, especially the offenders, and the judge should know exactly who's in front of them. They should know all about the offense and the sentencing. And we agree, of course, that at these hearings there should be a right to counsel. These will be, if there's not a negotiated solution, either a first sentencing hearing or for a retroactive case, a resentencing hearing. If there's not a legislative solution, litigation will continue. State Appellate Defender Office has a number of clients. Dakota Eliason, who Prosecutor Cooper mentioned as one of our clients. We're litigating sentencing issues. We're litigating retroactivity issues as amicus in the CARP case. We don't know yet if the Michigan Supreme Court case will take that case, but obviously litigation is going to continue regardless. But that dovetails in one of the points I'm about to make about legislation, which is legislation is a process that our state and this body can control, whereas litigation, there's a lot of uncertainty for all sides about how things are ultimately going to play out. So the last thing I want to talk about is why legislation that provides a retroactive fix and provides a term of years alternative is such a sensible response to Miller. And there are a few reasons for this. The first is, to be clear, it's the constitutional response to Miller. There's no question here, and this is prospectively. Obviously, reasonable minds could disagree about retroactivity, and I'll speak a bit more about that in a minute. But for prospective sentencing, Michigan sentences are clearly unconstitutional, and the Miller case quite clearly talks about individualized sentencing. The way to respond to that is to have a sentencing solution that, of course, allows life without parole in the uncommon case that the Miller court talked about, but also allows individualized term of year sentences where appropriate. For the sort of cases, Representative McBroom, that you were struggling with in your questions of answers, if somebody is a substance abuser in the time and is under the influence, it doesn't make them not guilty. But perhaps that's somebody for whom a proper individualized sentencing hearing needs to take place to see what the appropriate term of years sentence is. This legislature can't look at every single case and say, here's the sentence. But what the legislature can do is say, all right, for future sentences, per the dictates of Miller, let's look at all these mitigating factors and let's of course, leave life without parole in the mix, but also impose an appropriate individualized term of years sentence. Second, this legislature should look at consistency and fairness. Although nobody knows where the courts are going to end up on retroactivity, there's no question that this legislature can impose a retroactive solution. California has chosen to do so. Delaware has chosen to do so. I expect other states will as well. It's and I obviously we'll hear a lot and have heard a lot about victims' perspectives in the process, and it's incredibly important. But it is also important to look at the fact that if a sentencing scheme is unconstitutional and everybody to be sentenced from the day after Miller onward has the ability to receive an individualized sentence. If somebody received a life without parole sentence 30 years ago who didn't know any better to say yes to a plea deal, who was not the main actor in the offense, who was not the shooter, it's not necessarily fair, and this is where the legislature can come in to say, too bad, so sad, can't do anything for you. The Supreme Court may rule that Miller's not retroactive. California did something, Delaware did something for a significant portion of our client population and the 360 folks in prison. It's not necessarily the appropriate individualized sentence for life without parole. Third is, I would really implore the members of the legislature to look at Miller as an opportunity and not as an obstacle. The response to Miller should not be, good grief, we've got a problem here, we need to fix it. What's a really long sentence, such Attorney General Schuette mentioned 35 to 50 years. What's a really long sentence we can do to